You know, usually when we talk about diagnosing a problem, whether that's in medicine or mechanics, there's this distinct expectation of precision.
Right, like you want a clear answer.
Exactly. I mean, you think of it like an engineering schematic or something. Like you fall off a ladder, your arm hurts, you go to the hospital, and the x-ray shows that, that stark, jagged white line across the bone.
Yeah, the doctor points at the screen, and the reality of the situation is just completely undeniable.
It's totally binary. It is a completely binary state of affairs.
The bone is either fractured or it is intact. There's no in between.
Right.
And we build our entire understanding of the world on these clean categorizations because, well, they offer a sense of control. We desperately want the systems that govern our lives to be visible and measurable.
And ultimately solvable, right? Like through a clear set of steps.
Exactly.
But the moment you step out of a hospital and walk into the world of the American legal system, specifically that rarefied high-altitude ecosystem where immense multi-generational wealth collides with, really complex family dynamics.
Oh, yeah, that X-ray machine just completely shatters.
It shatters. We are suddenly looking at a diagnostic landscape that is entirely murky. It's subjective and it's highly, highly volatile. So today we are taking a deep dive into a set of sources detailing a case that completely defies those clean categorizations.
It really does. In fact, it is a statistical anomaly of astronomical proportions.
It is. And, let me just hit you with a staggering historical fact right out of the gate from the material we're unpacking today.
Lay on me.
There is only one inheritance case in the entirety of American history that has gone to the United States Supreme Court twice.
Which is just, I mean, think about the sheer volume of litigation in this country over the last 2.5 centuries.
Right. Millions and millions of disputes.
Millions. And yet this singular conflict over the exact same fortune managed to force the highest court in the land to intervene on 2 completely separate occasions.
Separated by, what, more than a decade of relentless legal warfare?
Yeah, over a decade. It's genuinely mind-boggling.
It really is. And we're analyzing a story featuring 2 central figures who, if you only look at the surface level, they seem like these crude caricatures ripped straight from a 1990s tabloid magazine checkout aisle.
Very much so.
But underneath that sensationalist veneer, they represent a collision of worlds that fundamentally expose the structural weaknesses of the entire legal system.
Right. You've got a 90-year-old oil billionaire on one side of the chessboard.
And a 26-year-old bride on the other.
Exactly. And sitting quietly between them, acting as the catalyst for this entire disaster, is the central mystery of our deep dive today.
A last will and testament that left this young bride absolutely, unequivocally nothing.
$0. And the mission of our deep dive today is to unpack the mechanics of that specific disaster.
Right, because we are not here to rehash the tabloid gossip
Yeah.
or, look at the paparazzi photos.
No, not at all. The sources we've gathered chart a mission to navigate a 16-year legal labyrinth. We really need to explore how a massive fortune, which was estimated at around $1.5 billion, by the way,
Billion with a B.
yeah, managed to completely break the legal system.
By mapping this out, we uncover what this case reveals about the catastrophic consequences of overlapping legal jurisdictions and the severe limitations of constitutional authority.
And, perhaps most importantly, the incredibly fragile, almost illusory nature of spoken promises.
Exactly. And you might be listening to this right now, sitting in traffic or maybe folding laundry thinking, well, this is a fascinating story about the ultra-rich, but I don't have $1 billion oil empire.
Right, so this doesn't apply to my life.
Exactly. But the legal traps that swallowed this family whole, the catastrophic assumptions they made about how the law actually works, the missteps in their basic planning.
These are the exact same traps that could tear apart any estate.
Any estate, no matter the size. Whether you're fighting over a multinational corporate conglomerate or just a modest 3-bedroom family home and a checking account.
The mechanisms of disaster are identical. The scale of the wealth simply acts as an accelerant.
Like throwing gasoline on a fire.
Exactly. More money buys more lawyers, which buys more time in court. But the underlying anatomy of the family breakdown and the legal gridlock, it's exactly the same for a teacher's pension as it is for an oil baron's trust fund.
Now, no spoilers yet on the final dollar amounts for this case, but I will tease you with the ultimate crushing irony of this entire saga.
It's a rough one.
It is. This story ends exactly where it began.
Yep.
But to get back to that starting line, it required decades of chaos, the generation of multiple contradictory realities, the destruction of multiple lives, and millions upon millions of dollars just burned in a furnace of legal fees.
And to understand how that even happened, we have to look at the people who built the powder keg.
Yeah.
We need to examine the billionaire, the bride, and this highly combustible blended family dynamic.
Let's do it. So, the popular cultural memory of J. Howard Marshall has really been reduced to a visual punchline.
Yeah, he's often just remembered as that frail, elderly man in the wheelchair sitting next to a glamorous model.
Right. And that image completely erases the historical and intellectual reality of who this man actually was.
He was a formidable, highly serious figure in American business, government, and law.
He wasn't a man who just stumbled into a fortune through like sheer luck or a winning lottery ticket.
Not at all. He was a Titanic oil tycoon who helped build what became one of the most significant energy fortunes in Texas history.
But the most crucial detail for our analysis today, the fact that frames this entire legal disaster,
Is his educational and professional background.
right, he was a Yale-educated lawyer.
And let's really hold on that point, because
Yeah.
it is the pivot on which this entire mystery turns.
He wasn't just a guy who took a few business classes on the side.
No, he was steeped in the rigorous, highly structured world of Yale law. I mean, he literally taught at Yale Law School.
Wait, he taught there?
Yes. He authored legislation. He knew exactly how the rules were written because, in some cases, he helped write them himself.
Wow. Okay, so by the time he meets the woman who would become his bride, he has spent over half a century navigating the most complex corporate structures imaginable.
Federal regulations, incredibly dense contract negotiations. He's done it all.
He understands the absolute unyielding necessity of the written word in the eyes of the law.
Right. He knows how to protect assets. He knows how to structure holding companies and how to execute airtight legal agreements.
And stepping into that highly structured, fiercely protected world is Anna Nicole Smith, whose legal name was Vicki Lynn Marshall.
Right.
And at the time they got married in 1994, she was a 26-year-old model and a Playboy playmate.
And he was 89 years old.
That is a 63-year age gap. 63 years.
It's massive. And they were married for just over a year before he passed away in 1995.
So you have a man nearing 90 whose entire life has been defined by legal precision and massive wealth accumulation.
Marrying a 26-year-old woman from a completely different socioeconomic universe.
The contrast is staggering. And not just in age or background, but in their relationship to the legal system itself, right?
Exactly. J. Howard Marshall is an architect of legal structures. Anna Nicole Smith is someone operating entirely outside of those structures.
She's relying instead on interpersonal dynamics.
Right. And because J. Howard possessed that deep professional understanding of the law, the sheer absence of legal documentation providing for his new wife is what makes the events that follow so deeply perplexing.
Yeah, because the central claim that would eventually consume the courts was from Anna Nicole's camp, and she asserted that J. Howard had promised her half of his fortune.
Half of a $1.5 billion fortune.
We are talking about $750 million.
This is an unfathomable amount of money.
But the catch is, he allegedly promised this to her entirely verbally.
Yes, multiple times, according to her camp, and often in front of witnesses.
But there was not a single shred of legal documentation. No updated will, no specific trust, no post-nuptial agreement, nothing securing this massive transfer of wealth for his new wife.
And as you said, for a Yale-educated lawyer, a man who knows that a handshake deal on $1 billion is legally invisible,
Right.
to rely on a verbal promise, it defies every single instinct he would have honed over 70 years in business.
Which forces us to analyze his intent. I mean, we are left with a spectrum of possibilities here.
We are. On one end of the spectrum, you have the theory of cognitive decline or romantic delusion.
Like that he was so swept up in the final years of his life that he genuinely believed his verbal instructions to his family would be honored just out of respect for his patriarchal authority.
Yes, that's one theory.
I really have to challenge that theory, though.
Go for it.
Because if you're a Yale lawyer, your brain is fundamentally rewired to see the world in terms of liability and contractual obligation.
That's very true.
You know that a verbal promise in the estate world is about as useful as a parachute made of tissue paper.
Good analogy.
It doesn't matter how much he thought his family respected him. He knew the law doesn't care about respect. It cares about signatures.
So where does that leave us?
Well, I look at this and wonder if this is the ultimate case of intentional omission.
Did he leave her out on purpose?
Yeah. Did he use verbal promises as a pacifier, knowing full well they held absolutely no legal weight, just to maintain peace in his marriage?
While simultaneously ensuring his empire passed exclusively to his bloodline,
Exactly.
it is the defining ambiguity of the case. And because he never wrote it down, his true intent remains permanently locked away.
It really does. But we also have to factor in the environment he was operating in during those final months.
You mentioned the bloodline, which brings us to E. Pierce Marshall, J. Howard's son.
Right. And Pierce was not merely a passive heir waiting in the wings.
Not at all. He was a highly involved, fiercely protective figure who had been actively managing the family's labyrinthine business empire for years.
Let me offer a different analogy here because I think this dynamic is just so critical to understand.
Okay.
Think about a highly secured, heavily fortified corporate server room.
Okay, I'm with you.
Pierce is the IT director who has spent decades building the firewalls, encrypting the data, and guarding the physical servers. The wealth is the data.
Right.
Suddenly, the CEO, his father, introduces a completely unknown, unauthorized user into the system in the form of a 26-year-old new wife.
Oh, that's a great way to frame it.
Right. From Pierce's perspective, this isn't just a family dispute, it is an existential security breach. The friction isn't just likely, it is a systemic certainty.
It is a very apt way to look at it.
Yeah.
Whenever you introduce a new spouse into an established family dynamic where wealth is heavily concentrated.
Especially with an age gap that crosses multiple generations.
Exactly, you are threatening the incumbent power structure.
Oh, absolutely.
The incumbent family members often view the new arrival not merely as a financial drain, but as a direct threat to the legacy, the control of the businesses, and really the historical narrative of the family itself.
Because Pierce had dedicated his life to this empire.
He really had.
And that incredible disparity in expectations. A son guarding the fortress, a new bride expecting half the kingdom based on a spoken promise, and an elderly legal genius who put absolutely nothing on paper to resolve the tension.
It set the stage for the inevitable explosion.
And that explosion detonated the moment J. Howard Marshall died in 1995 and the will was finally opened.
Because the reading of a will in a situation like this is the exact moment where abstract fears become concrete legal realities.
Right.
When J. Howard Marshall's properly executed, legally binding last will and testament was presented, its terms were stark and unequivocal.
It left Anna Nicole Smith exactly zero.
No trusts.
Yeah.
No massive cash payouts, no real estate.
Nothing.
The entirety of the massive estate, the voting shares in the corporate empire, all of it was directed to his son, E. Pierce Marshall.
I try to put myself in that room just hearing those words. I mean, you've been told you're going to be taken care of.
Right.
You've been told in front of friends and staff that you were getting half of everything.
Over and over again.
And then a lawyer reads a piece of paper and the number is zero.
The whiplash must have been incredibly physical.
Seriously. So immediately, Anna Nicole's legal team goes on the offensive. And they introduce a concept that becomes central to the entire 16-year war.
Isolation.
Isolation. They claim that Pierce, acting as the ultimate gatekeeper, intentionally and systematically isolated his father in his final months.
Right. The argument her team constructed was that Pierce used his control over his father's medical care, his security, and his daily schedule to build an impenetrable wall around him.
Wow.
They argued that J. Howard wanted to execute the legal documents to give his wife the money, but Pierce actively intercepted lawyers, blocked phone calls, and basically interfered with what would have been a massive inter vivos gift.
Inter vivos meaning a gift given during his lifetime, right?
Right.
But how does that actually work in practice? I mean, if someone is a billionaire, how do they actually get isolated? It sounds like a medieval siege or something.
Well, honestly, it often resembles one. When an individual reaches a certain level of physical frailty, regardless of their wealth or their intellect, they become entirely dependent on their logistical support system.
Oh, that makes sense.
Right. So if the son controls the payroll for the private security stationed at the front gate, he decides who visits.
Jeez.
If he holds the medical proxy, he controls the nursing staff. If he manages the schedule, he determines when or even if an estate attorney is allowed into the bedroom.
So the wealth doesn't protect the patriarch at all.
No, it actually funds the very mechanisms used to isolate him. The gatekeeper effectively controls reality.
That is terrifying. So her team is painting this deeply tragic picture of a captive billionaire, but the cornerstone of her entire demand for half the estate always circled back to the verbal promise.
It always comes back to the verbal promise.
She maintained that he said it multiple times in front of people who were willing to testify under oath. And from a purely human perspective, if 10 people swear on a Bible that they heard the man say, "I want my wife to have half," that feels like the truth.
It
It
does.
feels like a binding commitment.
And it feels incredibly compelling to a layperson because our daily lives operate on social contracts and spoken agreements. I mean, we make verbal deals all the time.
Yeah, exactly.
But this is where the sources highlight the brutal, unforgiving chasm between human expectation and estate law.
Yeah, they really do.
In the realm of probate, verbal promises, no matter how passionately they are delivered, no matter how many highly credible witnesses are standing in the room taking notes, they mean absolutely nothing if they contradict a properly executed written will.
I understand the logic, but man, it feels incredibly cold.
It is cold.
Think about how many times you tell someone, don't worry, I'll make sure your student loans are paid off if anything happens to me.
Right.
Or, I want you to have the summer cabin. The idea that you can say that, mean it with all your heart, and have it vanish into thin air just because you didn't hire a notary, it's really tough to swallow.
It is, but it's designed to be cold because the alternative is systemic collapse.
How so?
Well, the legal doctrine governing this is heavily influenced by the statute of frauds. This is a concept dating back centuries, which basically mandates that certain high-stakes transactions absolutely must be in writing.
Right.
And why? Because the most critical witness, the person who supposedly made the promise, is dead.
Yeah, they can't take the stand.
Exactly. They cannot be cross-examined. They cannot say, yes, I said that, but I was joking. Or I said that, but then she treated me terribly, so I changed my mind.
Because if you let a spoken promise override a signed document, then every single will ever written is instantly void.
Instantly.
Any disgruntled cousin or a fired employee could just walk into court and say, well, right before he died, he whispered that he wanted me to have the Ferrari.
Precisely. The courts would be flooded with unprovable claims, and the whole concept of property rights would disintegrate.
Total chaos.
The strict requirement for written, witness documentation is a necessary flood wall against infinite chaos. And the Texas Probate Court, which is where this battle initially took place, is fiercely protective of that flood wall.
I imagine Texas probate law doesn't mess around.
It doesn't. It is highly developed, incredibly precise, and generally very, very hostile to ambiguous claims that aren't backed up by solid paperwork.
So the battle lines are drawn in Texas, and the Texas judge looks at the situation.
Right.
They look at the written will, which clearly names Pierce Marshall as the sole beneficiary.
Yep.
They look at the claims of a verbal promise, and the Texas state court just brings the hammer down. They rule entirely against Anna Nicole.
Completely.
They state that there is no valid legal evidence that J. Howard Marshall ever intended to leave her anything. The written will stands. Pierce gets it all.
It was a total comprehensive defeat for Anna Nicole Smith at the state level. The probate court did exactly what probate courts are designed to do. They authenticated the written document and executed its terms.
And, for 99% of the population, that is the end of the line. The gavel falls, you lose, you go home.
Right, game over.
But this absolute failure in Texas is what catalyzed the most bizarre, reality-bending twist in this entire saga.
Oh, this is where it gets wild.
Because she was shut out in state court, her legal team looked for a back door, and they found one. This brings us to a completely separate legal universe operating on parallel tracks.
The California Bankruptcy Court.
Right.
This juncture right here is where the case transforms from a standard, albeit high-profile family dispute into a systemic anomaly that really exposes the strange architecture of the United States legal system.
Let's lay out the parallel timeline for a second so everyone's on the same page. While the massive inheritance fight was raging in the Texas state courts, Anna Nicole Smith was facing severe financial difficulties and had actually filed for bankruptcy in California.
Right. Now, it is crucial to understand that these are two distinct systems.
Completely distinct.
Probate dealing with wills, trusts, inheritances is almost exclusively handled by state courts. Bankruptcy, however, is a federal matter. It is handled by federal judges in federal courts.
So you have two different sovereign systems, the state of Texas and the federal government operating simultaneously.
And normally, these two lanes of the legal highway never intersect. A bankruptcy judge in California does not care about a probate dispute in Texas.
But then Pierce Marshall makes a move that changes legal history.
He really does.
He decides to cross the median and basically drive into the oncoming lane. Pierce voluntarily files what is known as a proof of claim in Anna Nicole's California bankruptcy case.
Which is just astonishing.
He basically raises his hand in federal court and accuses her of defaming him. He argues that by publicly claiming he isolated his father and stole her inheritance, she is ruining his reputation.
Right.
And because she is bankrupt, he wants the federal court to award him money from whatever meager assets she has left to compensate him for that defamation.
When you study this case, this moment stands out as one of the most catastrophic strategic blunders in modern litigation.
It's hard to even comprehend.
You really have to ask, why would his legal team advise him to do this? He had essentially already won the war in Texas. He had secured the billion-dollar fortune. Why chase this woman across the country into a federal bankruptcy court just to squeeze blood from a turnip?
It has to be hubris. It looks like a classic case of someone wanting to completely annihilate their opponent.
Yeah, that's exactly what it looks like.
He didn't just want to win the inheritance. He wanted to bankrupt her reputation and legally punish her for even daring to challenge him.
Hubris is exactly what it was, and the legal mechanism of his blunder is fascinating. When you file a claim in a bankruptcy proceeding, you aren't just dropping a piece of paper in a suggestion box.
What are you doing?
You are legally submitting yourself to the equitable jurisdiction of that federal bankruptcy court. You are knocking on the federal judge's door, stepping into their courtroom, and saying, I recognize your authority to resolve disputes between me and the bankrupt person.
Wow. So he practically handed her a loaded weapon.
He did.
Because the moment he filed that defamation claim against her in federal court, he basically kicked open the door for her lawyers to file a counterclaim against him in that exact same court.
Exactly. If he hadn't shown up in California, the federal judge would have had absolutely no reason or authority to look at him.
But because he demanded money from her, her lawyers said, oh, you want to talk about who owes who money? Let's talk about it right here.
Yep.
And they sued him for a specific claim called tortious interference with an expected inheritance.
And let's break down the anatomy of that claim, because tortious interference is a very specific, highly complex legal concept. It is not the same thing as contesting a will.
Right. Contesting a will means you are arguing the document itself is invalid, like maybe it was forged or the person was not of sound mind when they signed it. That is a probate issue.
Right, which she already lost in Texas.
Exactly.
Tortious interference is entirely different. It is a civil wrong. The argument here is essentially, I am not saying the will is fake. I concede the will says I get nothing. But the reason the will says I get nothing is because you, Pierce, wrongfully, intentionally, and maliciously interfered with your father's attempts to change it.
Oh, that's a brilliant pivot.
It shifts the focus completely from the validity of the document to the bad behavior of the son. She argued to the federal bankruptcy judge, the only reason I am bankrupt and standing in your courtroom today is because Pierce illegally blocked me from receiving the hundreds of millions his father wanted to give me.
And here is the plot twist that nobody saw coming. The federal bankruptcy judge in California listens to this argument. He looks at all the evidence of isolation, the timeline of events, the medical proxies, all the same underlying facts that the Texas court looked at.
Right.
And the federal judge completely agrees with her. He sides with Anna Nicole Smith and awards her over $400 million in damages against Pierce Marshall.
It is a stunning outcome. It is the legal equivalent of a structural earthquake.
I really want to make sure we truly grasp the absurdity of this moment. Let me offer another analogy.
Go ahead.
Imagine a patient needs a highly specialized open heart surgery. But instead of one cohesive medical team, you have two completely different surgeons operating on the same patient at the exact same time from opposite sides of the operating table.
Sounds messy.
Right. Surgeon A is reading from a Texas state medical manual, and Surgeon B is reading from a federal bankruptcy manual. They are looking at the exact same organs, the exact same heart, the exact same blood flow. Surgeon A looks at the patient and declares, this patient is completely healthy, sew them up, send them home. Surgeon B looks at the exact same patient at the exact same second and screams, this patient is dying, we need to amputate a leg.
And neither surgeon recognizes the authority of the other.
Exactly. You have a Texas state court telling the world, Anna Nicole Smith gets $0. Pierce gets it all. And simultaneously, you have a California federal court telling the world, Pierce owes Anna Nicole Smith $400 million.
It is a catastrophic jurisdictional paradox.
It really is.
And this paradox highlights a crucial lesson drawn from the sources. Overlapping legal systems are the ultimate wealth destroyers. The American justice system is heavily predicated on the concept of finality.
Right, the idea that once a dispute has been fully adjudicated, it is over. Parties can move on with their lives.
Exactly. When you have two separate sovereign courts providing completely contradictory finalities regarding the exact same set of facts, the system essentially shorts out. It cannot process the contradiction.
You literally have Schrodinger's inheritance. Depending on which judge's order you hold up to the light, Anna Nicole is simultaneously a half-billionaire and completely destitute.
That's wild. And the legal system cannot tolerate a tear in the space-time continuum like that. It forces a crisis that has to be resolved by the ultimate referee.
The Supreme Court.
Yes, the sheer gravitational pull of this paradox dragged this messy, tabloid-soaked family drama all the way up to the Supreme Court of the United States. Which brings us to the first massive constitutional showdown. Marshall versus Marshall, argued in 2006.
So when a case like this reaches the Supreme Court, there is a massive disconnect between what the public thinks is happening and what is actually happening in the courtroom.
Huge disconnect. The media coverage in 2006 was completely focused on the soap opera. Did Jay Howard really love her? Was Pierce a villain? Did she marry him for the money?
But the Supreme Court justices do not care about the human drama.
Not even a little bit.
Mm.
The core legal question before them had absolutely nothing to do with who deserved the money.
Okay, so if the Supreme Court isn't looking at whether Pierce isolated his dad, what are they even doing? Are they just reading the rule book to see which referee gets to blow the whistle?
That is exactly what they are doing. They are examining the constitutional plumbing of the legal system. The specific legal concept at play here was something called the probate exception to federal jurisdiction.
The probate exception. Okay, what is that?
Historically, federal courts have maintained a hands-off approach to two specific areas of law. Domestic relations, meaning divorce and custody, and probate, meaning wills and estates.
Got it.
The tradition was that state courts have the specialized expertise to handle those issues, so federal courts stay out of it, even if they technically might have jurisdiction based on the parties living in different states.
So Pierce's lawyers go to the Supreme Court and argue, hey, this entire $400 million federal judgment is invalid because a federal bankruptcy judge has no business meddling in a Texas probate dispute. The probate exception means the federal judge wasn't allowed on the field.
Precisely. Pierce argued that Anna Nicole's claim of tortious interference was just a probate dispute wearing a clever disguise. And if it was a probate dispute, the federal bankruptcy court lacked the jurisdiction, the legal authority to rule on it.
And how did Anna Nicole's team respond to that?
Her lawyers countered by arguing that tortious interference is a standard civil tort, like a personal injury claim, and therefore it doesn't fall under the narrow probate exception.
And the Supreme Court, looking at this incredibly technical argument, rules unanimously in favor of Anna Nicole.
They did, unanimously.
They decided in 2006 that the federal bankruptcy court did have the jurisdiction to hear her claim.
Yes. They essentially narrowed the probate exception, stating that because she was alleging a tort against Pierce personally, rather than asking the federal court to rewrite the actual will or administer the estate, the federal court was legally allowed to hear the case.
The ruling was blasted across every news network as a massive, total victory for Anna Nicole Smith.
Oh, everywhere. The narrative was that the Supreme Court had validated her fight for the fortune.
But this highlights one of the most brutal realities of complex litigation. The difference between winning the right to fight and actually winning the fight.
No, true.
I really want to drill down on this because it is baffling to anyone outside the legal profession. She wins at the Supreme Court. The highest judges in the country say, yes, you belong in federal court. Did she get a check for $400 million that afternoon? Did any money actually change hands?
Not a single cent.
Wow.
The Supreme Court's ruling didn't put any money in her bank account. It didn't validate the $400 million award. All they said was that the federal judge who made the award wasn't trespassing.
So they just gave her permission to keep litigating?
Exactly. It was a purely procedural victory that masqueraded in the press as a substantive one.
But why? Why wouldn't the Supreme Court, having read all the files, having seen the contradictory rulings from Texas and California, just say, look, this has gone on long enough. We are the Supreme Court. We are looking at the evidence. Pierce acted poorly. She deserves X amount. Case closed.
It's a fair question.
Why do they pass the buck back down the ladder and doom these people to more years of legal fees?
Because of the fundamental structure of the appellate system. The Supreme Court is not a trial court.
Okay, meaning what?
A trial court is where witnesses are sworn in, cross-examinations happen, and juries or judges decide issues of fact, who is lying, who is telling the truth, what actually happened. An appellate court, and specifically the Supreme Court, decides issues of law.
Right.
Did the trial judge apply the correct legal standard? Did they have jurisdiction? If the Supreme Court stepped in and started deciding the factual merits of how much money a widow deserves, they would be acting as a super probate court, completely overstepping their constitutional role.
Ah, I see.
They answer the narrow, abstract legal question asked of them in this case: does the federal court have jurisdiction? And then they remand the case, sending it back down to the lower courts with instructions to apply that answer to the messy facts on the ground.
So they essentially said, we have confirmed that the federal plumbing is legally installed. Now you guys go back down to the lower courts and spend another 5 years arguing about whose water is leaking.
That is a very accurate, albeit cynical, way to describe the appellate process.
So in 2006, Anna Nicole has the upper hand. She has a Supreme Court ruling in her pocket saying her federal case is valid. She is gearing up to enforce this massive judgment.
She is.
But just as she crests that hill, the unforgiving reality of time and human mortality interrupts the legal chess match. And it completely transforms this lawsuit from a high-stakes financial dispute into something out of a Gothic horror novel.
This is the inflection point where the story stops being a legal curiosity and becomes a profound study in human tragedy and the relentless momentum of the legal machine.
Let's track the morbid timeline here because it's unbelievable. J. Howard Marshall, the patriarch whose wealth started this entire conflict, died in 1995. The first Supreme Court ruling happens 11 years later in 2006. And then in early 2007, just months after seemingly gaining the ultimate legal advantage, Anna Nicole Smith dies suddenly and tragically.
She was only 39 years old.
It was a shocking event that stopped the cultural conversation in its tracks. But the legal machinery didn't stop.
Not for a second.
And then, mere months before Anna Nicole's death, E. Pierce Marshall, the son who had dedicated the last decade of his life to defending the fortress of his father's estate, he also died unexpectedly from a brief infection.
I mean, I want you to really absorb the surreal nature of this reality. You have a massive multi-million-dollar lawsuit that was born entirely from the personal animosity between a young stepmother and a protective stepson, arguing over the unwritten intentions of a deceased father.
And suddenly, as the litigation grinds on, all three of those principal actors, the father, the son, the bride, are dead.
All of them.
But the lawsuit survives them all.
It becomes a zombie lawsuit.
A zombie lawsuit.
It speaks to the terrifying, self-sustaining nature of complex litigation. When a legal battle reaches this scale, operating across multiple jurisdictions and involving hundreds of millions of dollars, it ceases to be about the human beings who filed the initial paperwork.
It becomes a corporate entity unto itself.
Because the humans are gone, but their estates remain. Suddenly, the people driving the lawsuit forward are executors, trustees, and armies of lawyers.
Right. The original human emotions that fueled the fire, the love, the spite, the grief, the desperate need for validation, those are all evaporated.
Completely gone.
They are replaced entirely by billable hours, fiduciary duties to maximize estate value, and abstract legal theories.
The battle lines were completely redrawn. On one side, you have the estate of E. Pierce Marshall, now managed by his widow and family, continuing the fight to protect the original inheritance.
And on the other side, you have the estate of Anna Nicole Smith, and who is the ultimate potential beneficiary of her estate. Her infant daughter, Danny Lynn, who was just a baby when her mother died.
Right. Imagine being that child's guardian. You inherit this unimaginable burden.
Oh.
You aren't inheriting a clean trust fund. You are inheriting a decade-old, multi-million-dollar legal war over a theoretical pot of money that is frozen in jurisdictional purgatory.
It's insane. You are commanding an army of lawyers to fight the ghost of a stepson on behalf of the ghost of a mother over the unwritten wishes of a grandfather who died before you were even born.
It becomes a purely abstract exercise in legal endurance. It is completely detached from the human reality it was originally supposed to resolve. It is a war of attrition where the only measurable progress is the depletion of resources.
And with the original combatants buried, these corporate entities, these estates, dragged this zombie lawsuit back up the mountain all the way to the Supreme Court for one final devastating showdown.
Round two.
This brings us to Supreme Court Round 2. The case is now called Stern versus Marshall, reflecting the names of the executors of the estates. The year is 2011. We are now 16 years removed from J. Howard Marshall's death.
Wow.
What happens in the second round?
Well, the legal landscape at the Supreme Court shifted slightly from 2006, but that slight shift was absolutely tectonic in its implications. The justices were no longer asking about the probate exception.
What were they looking at?
They were looking at a much deeper, more fundamental constitutional issue. In 2006, they asked, did the bankruptcy court have the jurisdiction to hear the claim? The answer was yes, they were allowed to listen to it.
Right.
But in 2011, the question was, did the bankruptcy court have the constitutional authority to make that final binding $400 million award in the first place?
Okay, I am going to need you to break that down because to a non-lawyer, having the jurisdiction to hear a case and having the authority to make an award sound like the exact same thing. What is the difference?
It's subtle, but huge. The difference strikes at the very heart of how the United States government is structured. It is about the separation of powers in Article 3 of the Constitution.
Okay, give us the civics lesson.
The Founding Fathers wanted the federal judiciary to be fiercely independent, completely insulated from political pressure or the whims of Congress. So they created Article 3 judges.
These are your federal district court judges, your appellate judges, your Supreme Court justices.
Right. They are nominated by the president, confirmed by the Senate, and crucially, they're given lifetime appointments and their salaries cannot be reduced. This ensures they can make unpopular decisions without fear of being fired.
Right. They are the untouchable core of the judicial branch.
Exactly. But as the country grew, Congress realized the Article 3 courts were getting bogged down. So Congress created specialized courts, like bankruptcy courts, to handle specific administrative areas of law efficiently.
Okay.
Bankruptcy judges are known as Article 1 judges. They do not have lifetime appointments. They are appointed for 14-year terms. They are essentially creatures of Congress. Therefore, because they don't have the ultimate independence of lifetime tenure, the Constitution strictly limits their power.
I see where this is going.
They are only allowed to make final judgments on core bankruptcy issues like restructuring debt or discharging loans.
So they have a very specific narrow lane they have to stay in. They can't just act like all-powerful federal judges.
Precisely. And this is the trapdoor that opened up under Anna Nicole's estate.
Oh, wow.
The Supreme Court in 2011 looked at the claim of tortious interference. They said, yes, Congress passed a statute in 1984 that technically allowed bankruptcy judges to hear claims related to a bankruptcy.
Right.
But the Supreme Court ruled that Congress violated the Constitution by giving bankruptcy judges the power to enter a final judgment on a state common law claim like tortious interference. Because tortious interference exists completely independently of federal bankruptcy law, a limited power Article I judge cannot issue the final binding ruling on it. Only an Article 3 judge or a state court judge can do that.
I am expressing sheer, unadulterated disbelief right now.
It's a lot to take in.
Let me get this straight. You are telling me that they spent over a decade fighting, bleeding millions of dollars in legal fees, dragging this case through the press, and taking it to the Supreme Court twice, all over a $400 million judgment that was essentially written on a napkin by a judge who wasn't constitutionally authorized to sign it.
That is essentially what happened, yes.
How does a federal judge sit on a bench in robes, listen to testimony, bang a gavel, and award $400 million without knowing they don't have the constitutional authority to do it?
Because the boundaries of constitutional authority are often invisible until someone pushes past them and the Supreme Court is forced to draw a line in the sand. The bankruptcy judge relied on a statute passed by Congress. He thought he had the authority. The Supreme Court ultimately ruled that Congress had overstepped its bounds in granting that authority, violating the separation of powers. It is a profound, incredibly important ruling on the structure of the American government, establishing a major precedent for what bankruptcy courts can and cannot do.
It might be a brilliant ruling for a constitutional law textbook, but for the people involved in the lawsuit, it is legal whiplash of the highest order.
Oh, absolutely.
Because what is the practical effect of that 2011 ruling for Anna Nicole's estate?
The practical effect is total annihilation of their victory. Because the bankruptcy judge lacked the constitutional authority to issue a final judgment on that specific claim, the $400 million award was legally invalid. It evaporated.
It just disappears into thin air.
Well,
An award that had been sitting in legal limbo for over a decade, reported on by every news outlet in the world, leveraged in negotiations, fought over by armies of appellate lawyers, poof, gone.
they're gone.
Deleted from existence because the judge who signed the paper didn't have the right type of constitutional badge.
That is exactly what happened. The Supreme Court effectively said the federal bankruptcy judgment is void, which means the only valid final ruling, length standing, is the original ruling from the Texas probate court.
Which brings us to the brutal, deeply ironic conclusion of this entire 16-year saga. Let's look at the final
You
tally.
do it.
After 16 years of nonstop scorched earth litigation, after flying across multiple state and federal court systems, after generating two separate landmark Supreme Court rulings, and after outliving nearly every single human being who was originally involved in the dispute, what did the estate of Anna Nicole Smith walk away with?
Nothing. $0. The estate of E. Pierce Marshall, and by extension his surviving family, kept the entirety of the $1.5 billion fortune.
This is the brutal irony that estate attorneys must point to constantly when they teach this case. I mean, look at the timeline.
It's a perfect circle.
Right. In 1995, a Texas probate judge looks at the will and says, she gets nothing, the son gets everything. In 2011, after a 16-year odyssey of unimaginable financial cost, emotional stress, and systemic chaos, the Supreme Court's ruling functionally restores that exact same outcome.
16 years of fighting effectively achieved a net change of 0. The final result matched the original ruling perfectly.
It is the absolute definition of a Pyrrhic non-victory.
The sheer friction of the litigation consumed vast amounts of the very wealth they were fighting to control.
So how do we synthesize a 16-year, billion-dollar legal disaster into something a normal person can actually use? We've explored the depths of constitutional law and family dysfunction, but what are the concrete takeaways? Based on the sources and our analysis, we can consolidate this into 3 major lessons that apply to absolutely everyone.
Definitely. Lesson number 1 is the absolute unyielding supremacy of the written document over the spoken word in estate planning. The sources make this abundantly clear. Verbal promises are legally meaningless.
Meaningless.
It simply does not matter how many times a loved one looks you in the eye and says they will take care of you. It does not matter how many friends, nurses, or staff members were in the room when they said it.
Right. If that intention is not captured in writing, properly executed, witnessed, and notarized according to the specific probate laws of your state, it does not exist.
The law requires paper, not memories.
That is a hard pill to swallow, especially in close families, but it is vital. Lesson number 2. Jurisdiction matters enormously, and overlapping legal claims are the ultimate wealth destroyer.
Oh, without a doubt.
If you find yourself fighting a legal battle in state court, and your opponent figures out a way to drag a piece of that fight into a federal court on a related tangent, the money you are fighting over is going to be consumed by the fight itself.
The gears of the justice system grind incredibly slowly, and they are lubricated entirely by money. When you force two systems to fight each other, the only guaranteed outcome is that the lawyers will get paid.
Which leads directly to lesson number 3, bringing us back to the human element at the center of this. Blended families and significant age gaps are structural powder kegs.
Yes, they require meticulous, transparent, and legally binding management. If J. Howard Marshall, a man who possessed a world-class legal mind, had simply implemented clear, documented provisions while he was alive, this entire tragedy could have been averted.
How specifically could he have fixed it, though?
Oh, he had multiple tools at his disposal.
Yeah.
He could have executed a bulletproof postnuptial agreement, signed by Anna Nicole, clearly stating she waived all rights to the estate in exchange for a specific upfront sum.
Right.
He could have created a specific, irrevocable living trust for her, funded it while he was alive, and placed it under the control of an independent trustee, entirely separate from Pierce's control.
Or a no contest clause.
Exactly. He could have included a robust no contest clause in his will. By choosing ambiguity, whether intentional or accidental, he basically armed the bomb.
It really forces you to examine how we handle our own affairs. Because you don't need $1 billion to create chaos. You just need ambiguity. And the source material briefly weaves in a fascinating factual nugget regarding the musician Prince that perfectly illustrates this point.
Oh, yes.
Prince passed away, leaving an estate valued at roughly $156 million. And unlike J. Howard Marshall, who left a clear will that contradicted his spoken promises, Prince left absolutely no will at all. Total silence.
And the result was exactly the same. 6 years of absolute chaos. Because there was no written directive, the default state laws of intestacy kicked in. This triggered massive infighting among half-siblings who barely knew each other.
Right, and incredibly complex valuation disputes with the IRS over the worth of his unreleased music.
And tens of millions of dollars drained in legal and administrative fees.
It proves the rule. Whether you leave a vague, legally contradictory situation like J. Howard Marshall or a total vacuum of information like Prince, the resulting chaos is identical. The void left by a lack of planning is instantly filled by litigation.
The overarching narrative here is that the lack of simple, clear paperwork dismantled a family, consumed resources on a massive scale, and tied up the highest court in the country not once, but twice.
Which brings me to the ultimate grim reality of this deep dive. When you look at the smoking crater of this 16-year war, you have to ask, who actually won?
Nobody won. The original parties all died long before the legal questions were resolved. The estate ended up exactly where it started on day one in 1995.
The lawyers, the armies of litigators, appellate specialists, and estate administrators were arguably the only long-term beneficiaries of this entire saga. Pierce Marshall and Anna Nicole Smith spent a fortune on legal fees fighting each other instead of spending that wealth on their families, their charities, or just living their lives.
It stands as a monumental testament to the destructive power of unresolved disputes and the hubris of believing you can outmaneuver the legal system without following its fundamental rules.
So as we wrap up this deep dive into these incredible sources, the central takeaway is starkly clear. A lack of proper, unambiguous estate planning isn't just a minor administrative oversight. It is a profound failure to protect the people you leave behind. It opens the door to 16-year nightmares.
But I want to leave you with a lingering philosophical question to chew on, one that isn't directly answered by our sources today, but sits heavily just beneath the surface of this entire story.
What's that?
What does it actually say about the underlying design of our American justice system? That it allowed a single familial dispute to consume the lives of three people, generate two completely contradictory legal realities operating simultaneously, and burn through 16 years of time and untold millions in resources just to arrive at the exact same conclusion a local judge reached on day one.
Is the ultimate lesson here that in the American legal system, when the stakes are high enough and the pockets are deep enough, the process itself becomes the punishment?
It's a chilling thought.
It's something you really need to think about. Thank you for joining us on this deep dive. And please, for the sake of everyone you love, get your affairs in writing. We'll see you next time.